All right, good day, everybody. Thank you all for joining us. And I feel like out of a sense of public health and safety, I need to warn you that I've got the flu, so you might want to wrap a surgical mask around your speakers or Lysol your computer after we're done or something like that. I just want to make sure you don't get a virus, either computer or otherwise, from the webinar. But other than that, we should be okay here. Today we're going to talk about some of the things to consider if you're approached as an agricultural landowner for things that might be non-agricultural uses of your property. And in Oklahoma, what that's kind of come to being is when we're talking about oil and gas development of the property, but in more recent years, we've also seen that take place in the context of wind energy development, and in even more recent times, in the past 3 or 4 years, we've started to see increasing interest in solar energy leasing as well. So we're going to talk about a couple of elements of the oil and gas side, kind of the traditional energy development, and then on the newer side of things, we're going to talk about issues to look at when you're evaluating a wind or a solar lease. Now, for lots of us in Oklahoma, we own or have a lease interest in just the surface interest of the property. And in Oklahoma, as in almost every other state, we recognize that we can separate the mineral interest out from the surface interest. And so as a result, over time, lots of surface property has been disconnected, if you would, from the mineral estate, which means we may not be getting a royalty check or an oil and gas lease if we're the surface owner, but we still have to deal with the surface impacts of oil and gas development. Now in Oklahoma, we have the Oklahoma Surface Damages Act that kind of provides a bill of rights, for lack of a better word, for those surface owners. So that's one of the first things I want you guys to understand, is that we do have a Surface Damage Act in Oklahoma, and that spells out the procedure for how we're supposed to go about negotiating with surface owners for the development of minerals underneath the surface. And what the Surface Damage Act is going to tell you is that we do things up front in Oklahoma. We require oil and gas developers to approach the surface owner to provide notice that they're about to begin drilling operations on the property, and to negotiate in advance for what those damages will be. Now you might be thinking to yourself, that seems kind of tough. Wouldn't it be easier for us to drill the well than actually ascertain what the damages were and then make the payment? But this was part of a compromise that was reached to pass the Surface Damage Act to make sure that the surface owner had the money up front for the estimated damages that would be incurred on the property before the drilling took place. That was kind of regarded as a way of helping everyone better balance the interests that were involved here. So what will happen is that the oil and gas developers are required to make an offer for what they believe the estimated surface damages will be, render that payment, or rather make the offer of that payment to the landowner. Now the landowner can accept that. If they do, they'll take the payment, they'll enter into a surface use agreement that spells out what's going to be done, the kind of controls that the oil and gas operator is going to take to make sure that damage doesn't spread, to mitigate the damages, to restore the property after drilling, and so on. If they accept that, they sign the agreement, drilling commences. If they don't, then what will happen is that in order to drill on the property, the operator is going to have to file a lawsuit, basically, with the district court for the county in which the land is located. And the first thing that's going to happen as a result of that lawsuit is that the oil and gas operator is going to request the appointment of appraisers by the court. The appraisers work in much the same fashion as they would with almost any other condemnation case. The procedure that we use for the Surface Damage Act is actually derived from the procedure that you use if you're condemning land. And what happens in the oil and gas context is that the oil and gas operator is going to choose one appraiser, the surface owner gets to choose an appraiser, those two appraisers then get together and appoint a third appraiser. The appraisers will evaluate the property, look at the plans for the oil and gas wells development, and then come up with an estimate of what they think the cost to the surface owner would be of the development. And the way that they determine that is basically the difference in the fair market value of that property before the development takes place versus the fair market value of the property after the development takes place. The difference between those two is supposed to be the estimate of the surface damages. If the landowner accepts that amount, then a surface use agreement is signed and drilling commences. If they still don't, then the case goes to a jury trial, and the issue before the jury is what was the proper amount of damages. Now it gets to be a little tricky at this point because you have to do some risk calculation. If you go to jury trial and the landowner gets less of an award from the jury than they were offered by the oil and gas company, they've lost the case, but also they have to pay all of the attorney's fees for the oil and gas company, so that can get pretty expensive. By the same token, though, if the jury awards them more than the oil and gas company offered, then the oil and gas company has to pay all of the landowner's attorney costs and fees. So it's a little bit of a risk calculation that you have to undertake if you decide that you don't want to undergo that. But all of that is to say, understand that you have rights as a surface owner. Those rights are protected by the Surface Damage Act. And the Surface Damage Act says that the oil and gas company has to make you an offer of the surface damages before they enter the property to drill. Now, it's important for you to think about what you're supposed to be considering in the Surface Damage Act. And we have a few cases that say when you're trying to calculate the amount of surface damages, we want you to be as comprehensive as possible in taking into account all of the impacts to the surface owner's use of the land and its value. So that can include things like the natural loss of land that's now going to be underneath the well pad, but also things like erosion damage, loss of access to certain parts of the property, or changes in cultivation practices that would have to be made. Basically anything that impacts the use of the land after the drilling will take place. So it behooves us as landowners to make sure that we have a means of backing up our assertions as to what any of those values are before we get involved with the surface damage negotiations. If you're a surface owner, it's a good idea, if you can, to have some sort of relationship and communication with the people that own your minerals, because that way you can get a heads up as to when development may be taking place, and you can kind of work together to make sure that you balance your interests. Now, I understand that in some cases that's a lot easier said than done, excuse me, because our minerals might be owned by one person. For example, if we just bought the property from someone and they retain the minerals for themselves, okay, there's one owner there. But there are lots of cases where the mineral owners may be dozens of people because the land has been passed through generations, and each generation further splits the minerals by giving their minerals in equal shares to their kids, and so on and so on and so on. So I understand it's not always possible to have a relationship with your mineral owners, but to the extent that you can, keep those lines of communication open so you can kind of know what's on the horizon with respect to those. Another thing that kind of catches some landowners by surprise is the fact that you don't have to take the surface use agreement that you're offered by the oil and gas company. I mean, the oil and gas company probably has a pretty good cadre of lawyers working for them, and that's the thing to remember, is their lawyers work for them, as lawyers should. They work for the people that are paying their bills. So you can have your lawyer draft a surface use agreement as well. Now, that's not a guarantee that the oil and gas company is going to accept it, but if it's reasonable, if it has commercially, viable provisions in it, and you're trying to make sure that you look out for your landowner's interests, some of those provisions might be adapted into the surface use agreement. Especially if you're a larger landowner and you've got a little bit more negotiating power, you might have a better shot at getting some of those factors included into the agreement, or having them use your surface use agreement as well. But just know that you don't have to take the agreement that's handed to you. You can develop your own if you want to. You should also consider maybe drafting provisions or drafting an entire agreement for exploration. Now, that's something that's often overlooked in Oklahoma, and that's the fact that the Oklahoma Surface Damage Act just covers the development of a well, okay, the drilling, production of oil and gas. It doesn't cover exploration. Exploration is usually accomplished by seismic exploration of the property, and in other words, we tend to give the earth a sonogram to see if there's oil or natural gas pockets down there. And so surface exploration through seismic means, and other means as well, by the way, that's not covered by the Surface Damage Act. There is the Oklahoma Seismic Exploration Regulation Act, which is a mouthful to say, and it says that there are provisions in there that are basically like the Surface Damage Agreement, the Surface Damage Act, that say there needs to be advance notice that exploration is going to take place on the property. There needs to be an offer of some sort of fee for the exploration, but that's kind of it. Things are largely left to the surface owner to handle that. And so if you have certain concerns about how seismic exploration might affect your use of the surface, well, you should have an agreement that you're prepared to offer to them to say, hey, if you want to come explore, okay, here are the provisions that we've got. Again, you don't have to take the provisions they offer. You can propose your own. That might include things like, I really would prefer that you guys don't have seismic exploration right after a rainfall, because that'll cause a lot of difficult to repair damage to pastures or croplands. And I know that That doesn't seem to be a concern in Oklahoma right now, given that we're all in drought once again, but it might rain again someday, and that's something to consider. Another thing you might want to consider is limitations on what we call shot hole explorations. Sometimes thumper trucks are used to create the vibrations that the geophysicists use to determine whether or not there might be oil and gas formations on the land, but sometimes they use explosives to create those vibrations, and you might not want those to occur within certain distances of water wells or established structures or things like that. Those are all things that you can spell out in the surface exploration agreement if you want to. When we're talking about the potential damage to property, lots of us are really good at coming up with the after picture of what the property looked like after the damage had taken place. But few of us have the foresight to say, you know what, we need to take pictures of what happened to this property before there was development. So I mean that literally. Take some before pictures, document with a camera, and timestamp your photographs what things look like before exploration and development took place. But beyond the literal before pictures, also make sure your farm records are in very good shape so that you can document the productivity of the land. You might want to take some water and soil samples just to kind of document the environmental baseline of the property, and that will help you out if down the road sometime you actually do have to document that there was damage to the property. We just talked about the importance of good farm records, things like soil analyses, water quality tests, but also your production records. The production records will help you show, for example, if there was diminished productivity in the land in terms of yields or returns, just generally. You can back that up with good farm records if you have them, but if you don't, that's kind of hard to do. Many times we talk about the actual amount of the damages and what's the dollar figure going to be, but we often don't think about restoring this land back to the way that it was supposed to be. Especially with today's horizontal drilling technologies and hydraulic fracturing, well pads are somewhat less numerous because we can reach more formations from one well pad, and that's a good thing, but those well pads, as a consequence, do tend to have to be bigger because they have to support more equipment and material being on place while we're developing the well. So think about provisions that might say, okay, once the well has been formed and properly finished out, can we reduce the size of the well pad so that it's not taking up as much space? Can we make sure that we reestablish vegetation? And that's another common issue. We hear lots of people talk about reseeding, but in a drought, reseeding I think means bird feeding, because you actually have to establish a fertile seed bed, water it, fertilize it, and make sure the vegetation actually gets reestablished. Think about ways that you can get paid that aren't money. And this is just a function of psychology. If you have to put a dollar sign on something, that hurts. But lots of times oil and gas companies may be willing to give you a lot more value if they don't have to think about dollar signs. And people don't do a good job of thinking about dollar signs when we're talking about in-kind things like grader services or bulldozer services or gravel or pipe or things like that. You might be able to get more material or earth-moving work than you would have gotten in terms of an actual check if you just asked for those kinds of things. And number 10, think about stuff that you can sell to the company. Water may be something of value that you have. If you have gravel or sand deposits on your property, that might be more cost-effective for them than having to truck that in from somewhere else. So think about the things that you could sell the company as well.